They wouldn't let you pursue a religious case at that time, I understand.
What the judge did in my case in November of '94 was exactly what the judge in the Bauer case did in '93 at the trial level. He said, we are going to follow these published precedents that derive from the Leary decision in 1967. Now, when we went to the Leary decision, it says right there, Timothy Leary cannot rely on the Sherbert defense, and they rule it out. And then every case after that of any kind of drug where a religious defense was mounted, all of those cases were summarily dismissed, or that defense was dismissed on the basis of the Leary precedent. So my judge and the Bauer judge both issued unpublished decisions where the marijuana laws were challenged under a brand new law. And by the rules of the federal courts, when the courts interpret a new law for the first time, they're supposed to publish the case so everybody knows, hey, this is the way we're supposed to do it. Or it gets overturned, and everybody knows, oh, that's the way it was, and then it got overturned. See? But in the case of corruption like we have in the federal court system in the United States, what they do in situations like this where they can't legitimately make an interpretation of law like that, they hide it by not publishing the cases. In the Bauer case, the Bauer defendants had very good attorneys out of San Francisco, and they were able to get an appeal mounted, and the appellate court, the Ninth Circuit, recognized the legitimacy of their defense and specifically the fact that Leary no longer applies. Leary was overturned by the Religious Freedom Restoration Act because that law says that the Sherbert and the Yoder defenses must be applied at trial. So
now the Religious Restoration Act, that was overturned in a case about peyote, wasn't it?
No, sir.
No?
No, sir. What happened was, since the Reynolds decision, which was a polygamy case out of the state of Utah in 1879, Supreme Court case, the Supreme Court and all of the other district courts leading up to the Supreme Court in the Reynolds case had looked at the fact of Reynolds' polygamy and said, we cannot allow a religious defense. We cannot recognize his religious defense to polygamy because polygamy is a threat to public health and safety of such a magnitude that it would utterly destroy our civilization if we were to allow it to happen, even under a religious excuse. Therefore, we have to convict Mr. Reynolds. Then a whole series of First Amendment cases, both free speech and religious exercise, leading up to Sherbert in 1962, I believe, verified the fact that when a First Amendment defense is made, that the court must examine the facts behind the case to determine whether or not what the person is doing by way of free speech or free religious exercise is a threat to public health and safety in fact, which means not only that the government has to justify the law with factual testimony and evidence, but that the defense has the opportunity to challenge those facts in front of a jury at trial. It's, in a sense, a jury nullification, a common law jury nullification procedure in federal court. Well, with Tim Leary, they nullified that in terms of the drug laws. They said, well, we're not going to apply that in drug laws. Then that went to the Supreme Court. Leary's conviction in '67 was overturned on tax issues, not on the religious issue. So the Fifth Circuit and all other circuits said, well, the Supreme Court looked at it. They didn't overturn it. Therefore, it's still our law. So they kept following it. But it was never a Supreme Court decision until Smith in 1988 or 1990, I guess. The Supreme Court issued the Smith decision. Now, Alfred Smith and Galen, G-A-Y-L-E-N, Black, Alfred was a Native American guy and Galen was a white guy. They were in Portland, Oregon. They were drug counselors at a local drug treatment facility. They were very good at their job, and others in the office were jealous of them. So they were called into the office and told that if they continued going to Native American church and eating that Schedule I drug peyote, that they would be fired. Well, they went. They got fired. They went down to collect unemployment insurance. The Unemployment Commission denied them, saying, well, you violated drug laws, and that's why you got fired, and therefore we're not going to give you unemployment. It went to the Oregon State Supreme Court the Oregon State Supreme Court said, no, this is a religious thing. All the other states pretty much recognize this in state law. It's recognized in federal law. We're not going to deny these guys their unemployment just because they went to church and ate peyote. Then it went to the U.S. Supreme Court, and in a landmark decision, the U.S. Supreme Court basically verified finally what had been done to Tim Leary in '67 and said, and this wasn't just about the drug laws now, but they said about all laws, whenever a legislature or Congress makes a law that applies to everybody, it's generally applicable, and it doesn't say anything about religion in it, it's religion neutral, that law will not be questioned at trial under the Sherbert and Yoder decisions by way of the way that those decisions were made. Well, that set it in stone, and all of the churches led by Reuben Snake, a Winnebago medicine man who was funded by Jeffrey Bronfman, who is the founder of the UDV Church in Santa Fe, New Mexico, which just won its big decision at the Supreme Court a couple of weeks ago. Reuben Snake promoted the Religious Freedom Restoration Act. It got passed, and it establishes in law that when a religious exercise conflicts with a law and it goes to trial, the defendant, once they prove sincerity, prove that they're actually really religious in what they're doing, they're not using it as an excuse, but they really are sincerely religious. Once they prove that, then the government must prove that what the person is doing is a threat to public health and safety, which is so large that it is a compelling interest on the part of government to stop it. Now, this is like somebody defrauding a bank with a pen of $1 million is not a compelling interest. Mm-hmm. But somebody driving drunk is a compelling interest because a drunk driver will kill people.
Yeah. It's a similar situation here, and we had a situation with Sunday shopping where it was prohibited to have your store open on Sunday, but it was shown that that was prohibiting freedom of religion because it was making Sunday people's holy days whether they wanted it or not.
Wasn't that Mark Emery's case?
No, it wasn't. Mark was involved with the Sunday shopping, but this was a different case altogether. I think it's Dollar Mart versus so-and-so or something like that. I forget the name of the case. But it's being cited in the motion that we're preparing here. And the situation here in Canada also with the medical exemptions being given out federally has created a situation where we could say, well, we can make exemption for another member of the public, other members of the public, because it's been shown to be safe and effective in the medical community, so that by allowing religious use of cannabis would just be kind of like a continuation of that same morality that allows medical use of cannabis.